Hello, everybody. Thank you for being here. We already have 210 people connected, and it's only 12, which is great news for us. So we're here for a webinar called A Candid Look into EB2 NIWs and RFEs from a former USCIS officer. I'm going to introduce her in a bit. We're going to wait for, as we usually do, for a few minutes before people connect. In the meantime, if people have any questions aside from the ones that were added during the registration, you can add them at the questions tab, okay? And whoever is already connected, feel free to let us know where you're connecting from. Where are people connecting from? Okay, everybody's typing. Salt Lake City, Utah, Uruguay, Washington, D.C., Fort Lauderdale, Turkey, Washington, D.C., Miami, New York City, Mexico, Boston. Wow, the world. Great. This is a great webinar. We're really excited. We actually have more than 500 people registered, so we're expecting to have at least 350 people connected. Most of our audience are immigration lawyers, which we appreciate because we work very closely with them. And knowing that this is an interesting topic is flattering. And we have a wonderful guest that I'm a personal fan of, so I can't wait to introduce her to all of you. Okay, so let me see. We have 255 people registered. Okay. Okay, I'm going to take it away. So hello everyone again, and welcome to today's webinar, A Candid Look into EB2 NIWs and RFEs from a former USCIS officer. My name is Marianela Mansour, and I'm a partner and director of sales and marketing here at Joorney. And it's my pleasure to host this webinar today. While we get started, I want to introduce Joorney to anyone who might be joining us for the first time. And I want to keep it simple. We do business plans for immigration, and we do a lot of EB2 NIWs. I know that many of you, and I know that as a fact, have vented about USCIS or are uncertain about getting an RFE or receiving mistakes on the case. So we thought, wouldn't it be nice to simply ask for an explanation or for more information from someone who has made those decisions herself? And that's exactly what we're going to be doing today. We'll discuss EB2 NIWs, RFEs, with someone who is uniquely qualified to explain why the USCIS makes some of the decisions it does. Her name is Mandy Nease, and she's a former USCIS officer with 13 years of experience as an adjudicator of a wide range of applications. She left USCIS to pursue a career as an immigration attorney, and today she works as an immigration attorney at Colombo and Hurd. Please join me welcoming Mandy.
Thank you. Such a lovely introduction. Thank you.
Yes, and Mandy is amazing. She's not only all the information that I included in the bio, but she's also a friend. So we appreciate Mandy being here. She's wonderful. I wanted to also mention before we get started that there's one CLE credit that has been approved by the Florida Bar Association for attending this webinar. If you are a member of another bar, we can provide the documentation you need to get your credits as well. You can send us an email. Like I mentioned, I will be, if you have any questions, you can use the questions tab that is on the right-hand side on the bottom. I will be asking Mandy some of the questions that we received from our registrants, and then at the end, we'll go into Q&A. I know that there's a lot of them. So let's get started. Let me just do something so that we're all on the same place. And let me confirm with the team that we can have the slides that you need, Mandy. 1 second. Julia is confirming. If not, we'll jump right into the questions. Okay, so we do have the slides. I'm going to share them. Mandy, feel free to flip them. You can do it from your part as well. Technical things that people understand. Great. Let's get started, Mandy. So you have a unique background.
So
Oh, go ahead.
not the presentation I was planning to give. We could do this one, but I
This
had
wasn't
some
the
other
one?
slides. So maybe we
Okay,
can take those down. We can talk about that. I mean, that national importance is one of the questions that involves a number of the questions that we got, but let me
or we can start
work
without
around
them,
this.
Mandy, if that's okay.
Yes.
Okay.
Please.
So, Mandy, you have a unique background with experience as an immigration lawyer and a former USCIS officer at the Nebraska Center. Tell us a little bit about yourself, your story, how you started at USCIS, and what the experience was to be on the other side and now as an immigration lawyer.
Okay. Yeah, I started with immigration in 2008. That was after the 2007 visa blizzard, if anyone remembers those days. I had left private practice due to just a combination of personal events and economic conditions, and USCIS was hiring. And I thought, well, that'll be a good way to get back to the Midwest. We were in Denver at the time, and do something a little different, maybe a little more secure. So I was hired there in 2008, and I started out doing EB 485s, green card application, because that's where the work was at the time. And so the visa blizzard work was really starting to clear out by that time. And so then we just had a variety of assignments, including TPS, sibling applications, asylum 485s for a while, I-130s, and then eventually with the first Trump administration, there was an emphasis on having interviews for employment-based 45 green card applications. And so that work went away from the service center, and I started doing I-140s. And when an officer trains on I-140s, everyone trains on labor cert cases and those subtypes and the premium components of that. And then when you're fully signed off and fully successful at those basic I-140s, then you are trained in a specialty or more, one or more, at least one. So for me, that meant national interest waiver and Schedule A petitions. For some officers, that means EB1s of a variety of types. But for me, it was Schedule A's and then national interest waivers. And then when I transitioned into private practice, I didn't really realize that national interest waivers were kind of a growth market at that time in like 2021. So I started doing those as a practitioner, and I've just been having a lot of fun ever since. So
from the other side, right?
From the other side, that's right. So we do here at Colombo Herd, I have an NIW caseload, an O1 caseload, an EB1 caseload. I do internal trainings similar to this, and mentoring and marketing for the firm. So lots of different things. After such a repetitive job, it's really a blessing now to have more variety in my day.
I can imagine, Mandy, for sure. I think the team told me that all the presentations are uploaded. So I have a green one, SOC codes, or I have Tech Enchanted Endeavors.
This would have been the Joorney webinar. It just has, it has like slides that are specific to the topics that we talked about.
Okay, let me have the team look for that one. In the meantime, so a little bit of a recap, right? We decided to do the webinar because there are a lot of assumptions that immigration lawyers make when they file an EB-2 NIW or receive RFEs and refusals, and there's a lot of uncertainty. So I'm going to name a few of those myths or truths so we can discuss them here, and then, as I said, we'll go into the Q&A. You were mentioning that the officers currently, they come from labor certifications. How does the training happen for them to review a file for EB2 NIW? And tell us a little bit about the mentors that are involved in this process as well.
So the training's about a week of in-class legal training. And with that, you get materials that include sections that are pertinent to the adjudication. So that can be, there's a section on the governing law, a section on the governing statutes, the case laws, the requirements for education, ability to pay, guidance on evaluating foreign education, right, through EDGE, and all of those things that go into determining whether a petitioner or whether a beneficiary qualifies for a particular I-140 petition. So there are written materials, and then there's a classroom presentation that includes PowerPoint and lots of QA. And then at the end of that classroom training, at the end of the week, you are assigned training cases. And those are live cases. They're not like pretend cases. They're live cases. And you co-adjudicate at least 5 with your mentor. Everyone's assigned a peer mentor. This is another officer who has been deemed successful, and they sit with you for the review and the computer process of adjudicating the case, making and issuing the decision in the case. Then once the mentor feels like they're comfortable, that you understand that process well enough, they allow you to review the files asymmetrically. So there's 5 that you do together. And then there's usually another 15 to 20 that are done together but asymmetrically. And so what that involves is the student reviews a petition, runs the security checks, runs the vibe check, and then completes the checklist, which I know is another question that we had from our audience. So they complete that checklist and they make notes, right? I would approve, I would deny for these reasons, or I would RFE for these things. And then those go to the teacher, and the teacher reviews those. And if they concur with those decisions, then they will indicate that they concur. If they disagree, they'll express that disagreement, and then they will come to a resolution, right? So let's say that I review a petition, and the Schedule 10K shows that the petitioner had a financial loss in the prior year. So I indicate on my checklist the petitioner does not have the ability to pay based on their Schedule 10K, and I will usually tab back in the paper file land, but now electronically, tab that piece of evidence for the teacher to review. And then the teacher can go to that spot in the file and look at that Schedule 10K and that operating loss and go, okay, that's correct. Or they might look at something else in the file and say, okay, the Schedule 10K shows an operating loss, but we have this updated information that's more current that shows that they have improved revenue, right? So there's that back and forth. We also, USCIS has a robust legal resource page, which is a SharePoint kind of page that includes their legal resources that you need to dig deeper if it's anything that's outside of what's in the classroom materials. So everybody gets copies of the checklist. I know we had a question about the checklist. And everybody works those files. And then when the mentee, mentor are finished with their training files, if the teacher believes that the student can proceed, if they understand the law and the process well enough, then they will make a referral to the supervisor. And then there are additional files that are reviewed by the supervisor.
Mhm.
So if then the supervisor reviews, I think they usually review another 10 files, maybe more depending on the student, but I think the minimum is 10. Then the student is fully signed off and can adjudicate on their own.
Okay. So that means that they'll review around 30 before they get to work, and that means that not everybody who goes to the initial weekly training gets assigned as an adjudicator necessarily. They need to be able to pass all these milestones, correct?
Correct.
Okay.
It usually happens. I mean, they don't fail very many students. Typically, you might see somebody requesting more, right? So they want to do another 5 or they want to do another 10 with supervision. But usually the students get there, they pick it up. It takes a little longer to pick it up because they're coming from less complex work, and understanding the I-140s takes some time.
Correct. Okay, understood. And within this training, aside from the 30 cases or approximate that they need to do on the classroom, how are they trained to evaluate substantial merit and national importance?
Great question. Luckily, I have my training materials right here.
Okay, thank
From the
God.
old days. Right? I know, right? So there's a PowerPoint. I have the old slide. My technology. Sorry, guys.
You're good, Mandy.
Okay, so there's just these components to substantial merit and national importance, which we're all familiar with. And so they talk about the components of those, the elements of those terms and the kinds of evidence that you can consider in evaluating those elements of the NIW, right? So for substantial merit, right, there's whether the endeavor is specifically described and whether the endeavor can show that it has merit in one of those categories, right? So business, entrepreneurialism, science, technology, culture, health, education, arts, or sciences, right? So they're looking at whether the endeavor is specific and whether it applies to one of those professional fields. And then we go into whether it has the potential to create substantial impact and whether the endeavor is related to any area of research or the pursuit of knowledge, right? The pursuit of human knowledge is also important, which is why I think so many people in this field gravitate toward researcher petitions, right? Because it's right there in the substantial merit analysis. Of course, research isn't the only area where there is substantial merit, but that does get that additional bonus. And then there's the potential to create that significant cultural impact, right? So maybe what you're doing isn't going to have a huge financial impact or a huge research impact, but maybe it has a cultural impact. So those are the things that officers are looking at when it comes to substantial merit. And so they just go through that and they talk about examples. They talk about the Danisar decision and what it was that Danisar was doing to create, that his endeavor had substantial merit. So they talk about his work as a researcher having substantial merit. So that's the training on that element, right? And then they go into the national importance element. And that has some components as well. So the DANISR decision when I was being trained was new. So a lot of my training was comparing and contrasting New York Department of Transportation to the new DANISR decision. I don't think that still happens because now the DANISR decision has been in place for a while and everyone's used to seeing that. Of course, we just had a recent policy memo on, refining some of the implementation of DANISR. So with national importance, they're looking again for impact. They don't want that impact necessarily to be oriented toward geographic location, although I think that geography still has a role. I think geography is something that we've maybe moved away too far from, because I think that that is still powerful. If we can show multi-state impact or regional impact, I think that that's potentially very compelling in these petitions. And so they talk about geography in terms of multi-state, national impact, and then they also talk about how local endeavors can still have national impact. So a local endeavor that might have national impact, the key example that is given in the training is a refinement to a production method, right? So I'm working in a factory in Kansas, and that innovation is in Kansas, it's maybe in Cargill and Wichita, and it has the potential to go to other plants in other states and have impact in other places, but it was still right there, right? So that's the first part of it, is that discussion about location and the ability to have location have national impact on its own, or to have local endeavors have a bigger impact.
So we're talking about impact, we're talking about knowledge sharing, we're talking about like something that is done that can be expanded to have enough importance to be approved, right?
Correct.
If that's what I understand. And I think this is why EB2 NIWs are sometimes challenging, right? Because there's a vagueness that requires some creativity into the file being prepared, right? Mandy, you mentioned when we spoke before the webinar about subject matter experts at USCIS. Who are they, and what do they usually do within this whole process?
So subject matter experts are experienced officers within a form type. And they're usually officers who have exposure to all the subcategories of a form type. And they deliver the training, and they do a lot of mentoring, and they handle litigation cases. So a few years ago, USCIS, like a lot of organizations, moved away from having career progression from officer to supervisor. So a lot of supervisors have never adjudicated, which I know is going to make people slightly ill being in this field, but it's true, and they're not always the worst bosses. They're often great bosses. So my favorite boss had never adjudicated. She was my favorite because she didn't tell me what to do. So a little selfish there. So the subject matter experts are people who have a lot of expertise in the form type and in adjudicating. And so they handle a lot of different kinds of tasks. They're tasked with delivering the in-person training. They do not train on other types of things. Training used to be delivered by subject matter experts for everything. And then they decided they should only train on the form. Other training that you get throughout the service center is delivered by trainers. So things like computer training, as we experience new updates to systems, if you're training on something else like diversity and inclusion,
Yeah, like more generic, more broader
mhm,
things that apply to different forms. But then they
right,
started specializing with the subject matter expert.
right, exactly.
Mhm,
And
mhm,
those officers will also work with the attorneys, the service center attorneys on litigation cases. Um, they do a lot of mentoring and they advise the
mhm.
supervisory staff on technical matters, right?
Okay.
So if I'm a supervisor, and keep in mind, adjudications is it's an evolution, right? It's a practice, just like what we do, right? So maybe I'm a supervisor now, but I haven't adjudicated in 5 years, right? So
Mhm,
my understanding and my technical expertise has shifted from adjudications to supervisory work. So I'm going to go to my SME if I have a question, a technical matter that I can't answer. Maybe my employee has brought me a technical matter and I don't know it. The example that I gave earlier about the Schedule 10K showing an operating loss, that's a real life example. That was one my boss brought to me.
mhm,
Another officer had found the Schedule 10K that didn't have enough money for to demonstrate ability to pay. And she was like, what the heck? And I was like, well, I mean, in the plain understanding of the training, we can't approve that they don't have the ability to pay. And there
mhm,
was a little bit of pushback from other supervisors on the staff about their ability to sell stock and raise money and things like that. And I was like, selling stock isn't raising money. I mean, it kind of is, but it's not. It doesn't improve the
mhm,
value of your organization.
mhm. Okay.
So, so there will be things like that. There will be weird cases, there will be weird fact patterns, and you'll need more expertise. And the production requirements of the officers don't really facilitate a lot of development of expertise, right? They're on metrics. And so if there's something that takes a while to figure out, they need to be able to go to somebody else who has the time in their expectations to look into it deeper.
Mhm.
If you're on metrics, as we all know, because I think everyone probably experiences some level of production metric, right? We all have to show something for our day at work.
Mhm.
Um, but senior officers, SMEs, they have different requirements than officers, and they can spend more time figuring things out.
Okay, let's talk about the metrics, Mandy. So what do you usually get, yeah, get graded for or get scored for? Is it approvals? Is it rejections? Is there an alarm where there are too many RFEs or too many rejections? How does that happen?
Those are really good questions. There's so the metrics are keyed to what you're doing, and they look at averages. So if you're doing, we'll just use labor cert cases. In labor cert cases, you have those delineations, right? So um, the expectation is, I think at the time I was adjudicating labor certs, the expectation was that you did 1.25 per hour. For
Mhm,
NIWs and EB1s, it's less, right? Because there's more to look at.
mhm,
But they will look at averages. So they'll say, the average officer is doing this many per
mhm.
day. And there's going to be a spectrum, right? We all know this. There's
Yeah.
always a continuum, right? Some people do a lot of cases at a really high level every day. Other people aren't there. So
Mhm.
there's always a range. They look for a middle, and then they set that. That is scaled on your performance. Okay,
Mhm.
so, and the scale isn't a whole scale. The scale is shades of gray. So 80% is kind of the cutoff. Everything over 80%, and that goes into your performance in a positive way. And you're eligible to receive bonuses and things like that based on your total performance score.
Okay.
Anything lower than that, if you drop below about 80%, they start looking at that and trying to figure out what they need to do to help you get to that 80% of the average. So if you're falling behind, they might do some things like retrain you. They might have you be mentored by an officer who is known for adjudicating quickly and at a high level. They'll do some things like that to try to help you get to that 80%. Otherwise, they have to put you on a performance improvement plan, and no one really wants that, especially if it's a good employee, somebody who's otherwise really a good employee.
Understood, Mandy. So we're talking about efficiency metrics here regarding the length that they take for a file. Do you remember like the range that would be for an EB2 NIW for an officer to review?
I think the metric was about 1 per hour. But there were officers. I had one friend. She was amazing. She, somewhere in the neighborhood of 15 to 20 NIWs per day, which I just always thought was amazing. For me, I would, somewhere between, 15 and 20, I would really start to get pretty fried. That wasn't really a sustainable pace for me. I was more in the 10 to 15 range. But I mean, she did it. She did it for years. Other people take a little longer, right? They really look at everything. And if you have denials and RFEs, that can slow your work down as well, right? And those all get counted differently. So when you complete your metric, your time accounting, you include the types of decisions that you made and for the I-140 subtypes that you made them on. So that all goes into that calculation, and thankfully that's all done by the computer, right? So you're not trying to like figure out at the end of the day if you were at your count, although early on everyone did. You would keep like literally a piece of paper with your count on it. Yeah.
Okay, glad that there has been progress there, but we'll talk about the software in a little bit as well. Okay, so that's really interesting, right? And it's kind of like it's good that immigration attorneys know, but it's also a little bit tough, right? You spend months preparing these files and then understanding that they only take certain minutes to review it. Basically, it's hard. So then I'm gonna ask like the questions that an attorney would usually ask for. Do they really read the file? Do they read the business plan? How important is it? What's happening in that skim or that reading, what's happening in those 45 minutes to an hour that you're reviewing that? Or I mean, probably less according to what you mentioned other people were doing, but let's say 30 to 40 minutes. What is happening? What are you looking at?
Right. I mean, if you do 20 per day and you're working 9 hours a day, I mean, it's maybe 20 minutes per file.
Exactly.
I think would be about the max. So there are some things that get skimmed. They don't get a lot of attention. The cover letters. This is my favorite piece of information to share with private practitioners because it's so crucial to what we do and the service that we think that we're providing to our clients. And adjudicators do not appreciate your lengthy cover letters.
Okay, short cover letters, people.
Shorter or.
Okay. Do you have a length preference, Mandy, to not let that question go? Like, how long would an ideal cover letter would be?
So my dream personally, and I can't convince anyone that it would be okay, is to have something that would read like a magazine table of contents, right? Where it's a description of the exhibit and like a 1-sentence teaser or something like that. But I can't convince anyone. No one feels safe
Yeah,
No one
I can
feels
see that.
safe with that methodology. I would say no longer than 10.
Okay.
I would say if you can pare it down further, get to the point. You know,
Okay.
I think the thing is like for practitioners who have maybe ever practiced in a high volume courtroom, right, where the judge has 100 cases on the docket, um, you have to really be succinct and you have to be direct when you get your opportunity to speak. And I think if people could visualize the adjudicators work in a similar way, I think that would help because, and also the seriousness of it, right? That you need to be direct and you need to be clear in the communication. You need to structure the information well so that the adjudicator can follow it and find all the pieces of evidence that they need to find. But they do not embrace any level of puffery or exaggeration or um, exposition of the facts. They just are
Mhm.
not here for it. And it's so sad because we all spend a lot of time on those letters and they're not
Right.
received in the manner that you might think.
Okay, so no BS, straightforward, no fluff.
You got
Keep
it.
them shorter than you are sending them today, basically.
True.
Mandy, and what about the business plan? What are your thoughts on the business plan? Do they even read it? And I mean, not because we're a business plan company, you can be as candid and honest as you want.
So the business plans, I think, do get more attention, right? So for prong two, demonstrating commitment and having a plan toward advancing your work in the US is a critical component. That is part of prong two. So they do want to see those details. They know that a lot of it is perspective. They know that a lot of it we don't know yet, right? Unless it's an existing business with an existing business plan or a startup that has a pitch deck or something like that. They know that it's perspective. They want to see whether it's connected to reality, right?
Mhm.
So do we have some financial support? Is what we think we're going to earn realistic for the field? Um, do we have a plan for marketing? Do we have any connections to help us get this going in the US? Do we have the expertise to make that happen? Not just
Mhm.
in terms of like the field, but also like any business acumen, right?
Mhm. Exactly.
Have you ever done anything like this before? And do you have any ability to carry that forward? And so I think the business plans, I mean, I don't know that they get, it's not like when I read them now, when you send me in a business plan for one of my clients, I mean, I look at it pretty closely and I might give
Mhm.
feedback, I might have edits. They're certainly not doing that. But again, they want to see what's in there and whether that seems to be connected to reality.
Mhm. Okay. Great. That's great news for us. They read it. So please add
That's
one. And also in
right.
the policy updates they were mentioned. So that's really good news for us. But in general, I mean, it makes sense, right? What you're saying. They want to see that there's a plan. They want to see what's behind it and that there's some structure to the endeavor itself. So that's good news. Let's talk about cookie cutter RFEs, because that's another venting topic that we get a lot. What's happening? Is it true that there are templates for RFE responses? Are you using some kind of software? What's happening with the RFEs?
So RFEs do have a custom software to them. So if people will recall getting an RFE, the RFE has a barcode on it. In a paper world, now they have IOE numbers, but in the paper world, you would get those LIN receipt numbers, LIN or TSC receipt numbers. Those numbers are attached to the physical file when physical files were still in existence. And so the officer scans that barcode from the file into a custom software. that custom software knows the petition type that's associated with that receipt number, and it will pull up standard language for that form type and that subtype that the officer can select from to include in the RFE. And so those are organized by the elements of the NIW and the preference classification requirements. And you just select, there's a brief description, and I believe they have numbers. You select the language that you intend to use, right? There's an introductory paragraph that we're all familiar with. Although I
Yes.
think the big introductory paragraph, that page 1 is always standard. So there's no language on page 1 that's selected by the officer. Everything from page 2 and on is selected by the officer. And so you just pick, what do you think, based on the deficiencies that you see in the file, and then it creates an editable form that you can then go in and add your custom facts and your impressions of the evidence so far, right? So I might choose some standard language on national importance, and then I might go into the letter and talk about the evidence that was included in the petition and why I thought that was insufficient for approval. And I might even, if I know, or if I think I have an idea about what might exist, I might also clue the lawyer in to what I'm looking for, depending on what the situation is, right?
Okay.
So I do all of that editing myself. What I think and I have this in my RFEs too, depending on the location of the officers, I think different officer groups are better and worse at paying attention and doing those edits. The officers often keep an informal set of snippets. Okay, so when we select those standard language, we call those snippets. Officers will also keep their own canned language based on common issues that they see in their practice area. And so they might sweep that in. That's where I think we see legal and factual errors. They're not editing that. The standard snippets won't have any facts. They won't include anything about the actual evidence or professional field. So those errors that we see referring to somebody who's a lawyer as a pilot, misgendering, things like that, that is not happening from the snippets. That's happening from the officer's own reserves of canned language, and they're not editing them.
Okay, so that's happening maybe when they're wanting to reach their KPIs or something. And then, I mean, human error.
I mean, maybe, or maybe they're just not being careful about it, right?
Exactly.
Maybe they're not rereading it and going, okay, does this actually make sense? I'm sure no one here has ever done that. I'm sure it's never happened in any other setting.
To anybody.
But yeah, I mean, it can be speed, right? Because everyone does have these metrics that they're working on, and it can be inattention to detail.
Correct.
It can be lack of oversight too. And not having enough training on, like, you have to pay attention. You can use this language, but you have to edit it. Most officers who have been at it for a while, if they're keeping their own body of work, they will clue themselves into the things that need to be edited. They will bracket, they will highlight, they will do things to cue themselves. They got to go edit these portions of the language. But not every officer does that. This is a profession like any other. You're going to find people who are great at it, super detail oriented, and you're going to find people who are not as detail oriented.
And I think from experience of immigration lawyers that are filing EB2 NIWs, they have seen how this might have impacted some of their files for sure. But it's a little bit reassuring that it's not the CRM and it's not the snippets that they're bringing that information from. It's human error that happens after. Of course, we all want them to be less, but that explains a lot. So maybe we can touch a little bit more on that as well. Recommendation letters, how do officers view them, and what makes them credible in the eyes of a USCIS officer?
I think they do read those letters of recommendation. They know that they're curated, right? I mean, you're not sending a letter of recommendation from someone who doesn't appreciate your work. So they know that. I would say that that to a degree diminishes the impact of the letter of recommendation, although some of them, are really impactful because they really discuss in detail and they give a lot of story to the evidence, right? So you might have evidence in your file about a technology that you innovated, and the letter of recommendation might give some context and tell the story of the impact of that technology innovation on the field. That's an ideal letter of recommendation. It gives some context to the importance of your work, and it tells your professional story. It helps the officer connect the dots, right? I could send in a pitch deck showing an innovative technology, and maybe that resonates with the officer, and maybe they're just like, okay, I don't get it, right? So something that tells the story and connects to the other evidence in the file, I think, is the most impactful letter of recommendation. And again, the officers steer away from puffery language. They don't like that. They really want it to be concrete. And obviously they know the source is friendly to the beneficiary of the petition. They know that. But if it can be connected to the other concrete evidence in the file, that's what they're looking for. They know that's your friend. They know that person thinks you're great. But
Exactly.
do they have reasons to think that you're great other than, you just have a great relationship with them?
Exactly. So focus on the impact, not the fact that it's just adding a recommendation letter to the file. Okay.
Correct.
And that it connects to the other documents that you're also filing on the case.
Right.
Okay.
And the other elements of the petition. Yes.
Okay. Exactly. Mandy, so it's interesting because you've been on the USCIS side. You are an immigration attorney right now, and it was funny because before we were doing the webinar, the day that we were discussing about what and how we were going to do it, you were just in the middle of venting about an officer's RFE response to your file. So you were debating between going full force to reply to that RFE and facing the officer, or deciding to refile, which leads to my next question. Why, what would you do, and why do some officers seem biased that you would need to refile?
Well, I mean, I think there are people who are operating with a higher burden of proof. And I think that can be a reason to refile, right? I think that day, I mean, it was an RFE, an all-prong challenge on probably the most qualified person that I've ever represented in an NIW. And I was like, it was so disorienting. It was just completely disorienting. I've had others too. I think maybe I told you the story. In my prior job, I had one where the person was a technical innovator and had received funding from University of New Mexico's agricultural innovation branch to make their product. And they received this RFE that literally criticized every letter. I mean, the RFE was incredibly lengthy. It was probably 20 pages long. And it went into such intense criticism of the petition. It kind of blew me away. And as soon as I started reading it, I knew who had written it. And I was like, yes, I knew the person, and I'm not proud. Well, maybe I am a little proud to say it. I'm going to say it publicly. I was about ready to go start a fight with that person. Like, I know where that person parks. Like, I'm coming there, you know. I was so frustrated with that, but this person was an NIW officer at the time. He had been an EB1 officer who denied 90% of his cases. When you have officers that do not approve, and you should be tracking that information, I know we do, when they don't approve anything, stop wasting your time and your client's resources, you know, and I include their emotional resources when I say that.
Yes.
Stop it. My client for that RFE was at the White House receiving a LATAM Entrepreneurship Award and had it sent me a picture with Kamala Harris, and his case got denied. And I was like, I'm gonna lose my mind. So it was the wrong decision to get sassy and to try to respond to that RFE. I should have cut that bait, let it sink to the bottom of the ocean, and start it over.
Okay. And you did? Did you start over, or you?
Yeah, we did
you
eventually. Yeah.
Okay.
No, we did. No, I responded to that thing, and I was so sassy about it, and I shouldn't have been. And that's, I mean, you know, if you're gonna take any other components of my advice, take that one. You know, know when to walk away.
Exactly.
Knowing when to walk away is super important.
Yes, I think that's a big one, because you get devoted and passionate about making sure you win, but I think that when there are enough signs, it's better to go another way, for sure. And I think we've discussed this in previous webinars. And I remember with Colombo, with Anthony, we discussed that they were keeping track about the numbers on the officers, and how harsh or how much of a high burden they had in order to get that. But of course, not every firm can do that, because they don't file as many EB2 NIWs. And at one point, we actually, as Joorney, we were trying to see if we could get the number of the officer and start tracking those, just because we see so many of that. We haven't figured out that part yet, but I agree that it would be extremely valuable to make those decisions. Let's talk about denials. What are the most common reasons USCIS issues RFEs or denials in the cases?
And national importance is always, I mean, almost always where they're going to hang their hat.
Okay. Okay.
It's the squishiest, you know, it's so amorphous. It's not defined really well by the law, and it's the hardest one to show, right? And so if you haven't done that, if you haven't provided enough concrete evidence about the prospective national impact, they can just toss it, you know. And they might be critical on some of the other prongs as well, because if you're not going to get prong 1, if you're not going to get national importance, you're probably also not going to get prong 3, benefit to the US. And so that's a common combination on RFE and denial. Benefit to the US is not extremely well defined either, and so that's another easy one. Although I think that officers, you know, they throw in prong 3, but the focus is almost always on national importance. My experience.
Mandy, there are a lot of, again, there's a lot of venting about mailroom shuffle, the mailbox, the lockbox. I know you mentioned. Can you tell us a little bit about how that part is organized? Because I'm sure a lot of immigration attorneys are going to want to know.
Okay, so a little bit of context, okay? So in paper filing days, as you will all remember, if you filed premium, you filed directly to the service center that had jurisdiction over the file. Recently, USCIS started having everything go to a central lockbox location. And at the lockbox, it is scanned and uploaded into the electronic adjudication system. So we're not sending anything to the service centers anymore. So when you would send a premium processing petition to the Nebraska Service Center, it was compiled, the file was compiled by Nebraska Service Center clerks, and they were on point every time. The work was, I mean, as close to flawless as you could get. They were amazing. The ones that went through the lockbox just generally, right, that you would file in a more general way, not premium, those were usually compiled at a pretty high level as well. During the pandemic, everything was going through the lockbox, and the lockbox closed, and they had reductions in staff due to the safety concerns around the pandemic, and they got backlogged. And while they were working through that backlog, the work product went down. The quality of that product went down. The files were a hot mess. And I mean, and I mean bad. So things like I would find elements of an I-140 petition in a spouse's 485 application, like a totally different physical file. It was awful. And the process to remedy that and to report that is also in depth, right? So every time I would find one of those errors, I would have to go through a process of reporting that error and documenting where the evidence was and where it should have been, all of those things. So there was it just fell off a cliff in 2021. It kind of evened back out. Well, now there's all these cases going into the lockbox, and they all have to be scanned and uploaded, and they're dealing with the premium processing pressure as well. And the quality, again, has fallen off. I've never been a huge fan of the lockbox. I never felt like their quality was reliable enough. But it's very difficult to impact that when you're an officer. All you can do is report it, right? And when they have so much to do and they have their own metrics, right? They're just trying to get through that work. It's super frustrating. It's frustrating for the officers too, because now all I have is the electronic file. I can't rummage around in the physical file to see, did it get lost? Is it somewhere else? Is it with a family member? So if it's not there, it is not there. I mean, you'll see the connections, you'll see the dependent files in the electronic adjudication system. But the access to rooting around in those other files is limited. And I don't even know if that's still happening, right? That's a problem for physical file world. Now we have this transition from physical file, everything's getting scanned and uploaded into an electronic system. And I think that there are different challenges to keeping that paper organized and uploaded correctly. And it's bad, guys. And all I can say is make sure that your table of context or contents is on point, because the officers will take a look at what should be in the file as they're rooting around and trying to find things.
Okay. Yes. Is there anything that an immigration lawyer can do to minimize those issues affecting their file?
So I think the primary thing is how you organize the file. And I have tips that I think will work. I don't know. This is it's new territory, right? New errors, new solutions. I don't know whether this will work. So my thought is, when you do your exhibits, regardless of the kind of petition that you're filing, when you do the exhibit number and page, first of all, it should just be on regular paper. It doesn't need to be colored or tabbed physically. Put the exhibit number and a blurb about where it's supposed to be in the file, right? So exhibit 1, maybe educational documentation. So exhibit 1, preference classification, degree certificate, something along those lines, where the exhibit has the number, but then also a blurb of what it's supposed to be. I think that helps officers, because they can look at the review of the PDF like we would when we do the organized file review, and they can see those cues on that exhibit page, right? They can see what should be there. So that's one tip that I have that I think will help with these terrible issues.
Okay. Thank you, Mandy. Another question we usually have, premium processing RFEs. Are these files automatically RFE'd? That's a big question mark most immigration lawyers have.
No.
The answer is no.
No.
Okay.
I would say,
Good.
I think the thing with RFEs is, they take more time than approvals. I'm not really sure what's going on with the high rate of premium RFEs. I think everybody's stressed out by the premiums and they don't know what to do. And there's probably changes in guidance and stuff like that too that is just adding stress to that decision. Because I never wanted to see a file twice if I didn't need to. I don't want to take the time. I mean, approving a case takes no time. It takes no time.
Yes.
Writing an RFE takes time. And so in terms of metrics, it doesn't make sense. It could be additional scrutiny. There could be fresh people trained. I mean, I always saw the increase in RFEs as more of a training issue than a premium issue, but no, there's no requirement that that premium be treated any differently. And the thing is, and there's differing opinions, but I always saw premium as a big benefit to the agency and a contributor to its financial well-being. USCIS is not funded by the federal government. They're mostly funded by the income that they earn, and premium is a big part of that. And so I was like, if I want a bonus, if I want to have overtime, if I want to have any extras, I got to get these premiums adjudicated. So I think the thing right now, and I don't know what the numbers are, maybe someone else out there in NIW land knows what the numbers are, but there's been a big increase. I mean, all these broken clocks, that has to do with volume. And I think when you see increased volume, obviously you see new people have to be trained, old people who were trained on it have to come back, and it's stressful.
Exactly. And that explains a lot. From your experience, Mandy, and to conclude before we go into the Q&As, what's going to change with the new administration? And I think you were there for Trump 1.0, like they say. What do you think is going to happen now with Trump 2.0?
Bad things.
Okay, share. Please share.
So I think employment-based immigration is going to be relatively safe. Okay. I don't think very many people in the Trump administration at the high level have any sense of employment-based immigration and what it involves and what it entails, what's in place, what would need to change to make things better or worse. I don't think they have any idea. I don't think they're going to mess too much with I-140s or the other employment-based non-immigrant statuses and things like that. I can see them going back and re-emphasizing the need to have a lot of green card interviews. I can see things getting tougher at the consular officer, at offices and those ports of entry. Obviously, is going to take every swipe he can at every humanitarian program that exists, because I think that for him, that's low-hanging fruit, and there's not a lot of pushback, right? The business community has a lot of political clout, and when they talk about their need for talent, politicians listen to that. They do. They have that political clout. They have money and they can donate to campaigns. They cannot donate to campaigns. People who are on humanitarian parole, who are on TSP, they don't have that kind of status or means to influence the politics. And so I think that those programs are vulnerable. Although the resistance is quite strong. I mean, I'm quite proud of how the private bar has responded to all of those shenanigans. My primary concern over all of it is, well, I have two primary concerns. One is impact on the federal workforce and just not having people to do the work, and overall economic contraction, and not people feeling like they don't have the means to hire private counsel, to pay for premium processing, to pay processing fees, whether those are regular or expedited. I worry about those things a lot, and I try not to catastrophize too much publicly, but those are my concerns because I think that that impacts our ability to continue on in the manner that we have. Um, I really think about diversifying the NIW practice to include some non-immigrant paths, especially in light of visa regression. And I think about, advocacy work on the number of visas that are allocated. I think about the resistance work on, filing lawsuits to combat these impacts on the humanitarian programs. I think all of those things are going to work. But if there's no one there to adjudicate the cases, you have a different problem.
Exactly.
And I don't know what's going to happen with that.
So that means less people. That means people who will be assigned to adjudicate might not have the proper training or not the whole patience of the process. And this could increase the amount of mistakes and oversights that we were mentioning before, right?
Right. More variety in the kind of decisions, more errors in the decisions, more errors in the RFEs, less accountability, and further wait times.
Yes, super clear. Mandy, and considering that, let's say many of these are things that we cannot control, let's talk about the things that we can, right? What are the common mistakes that attorneys make when they prepare an application for their clients? And what advice can you give them specifically for EB2 NIW based on your experience? Aside from the cover letter recommendation, which was really good, and the table of contents.
I think that some of the common errors that I see in national interest waiver practice is client selection, not selecting clients who have enough evidence to show that they have a viable endeavor in the US. And then beyond that, I think that we've all kind of been operating in a world where adjudicators consider a few of the elements of the DANISAR decision. And I think the new world of NIW adjudication includes looking for more elements that are of what's described as important in the DANISAR decision. So not having enough evidence about the scope of the endeavor, not describing the endeavor as in broad enough terms, and threading that needle correctly of its specific and also it's big enough to have a national impact, and it goes beyond a particular job, right? Because that's another area where we see some hiccups is between this job description and the endeavor and the SOC code selection and things like that. The other thing that I can see is not connecting enough of the dots in the story, right? So is your client proficient in their field, and do they have enough proficiency in advancing their work outside of an employment setting, right? Because in the NIW, unless you're dealing with corporate clients, which there are, right? We do see employers petitioning for NIWs, but unless the majority of them are those self-petition. right? So do I have the acumen to do this on my own? And do I have the connections and the financial backing and the interest in the US to do this on my own? And is it viable, right? Is the reality there in the evidence, or is it all um, a dream, right?
Mhm.
Because I think the days of NIW dreams getting approved is starting to, I mean, we're seeing the sunset on that
Mhm.
practice.
Okay, that's a really good point. Because I remember talking to a few immigration lawyers saying like, I feel that my EB2 is being like evaluated as if it was an E2 because they're asking about investment and they're asking about the economic aspect. So what you're saying aligns to that, right? They're looking deeper. And that doesn't mean they're looking at the wrong things, but rather trying to find that argument and evidence that makes the officer feel that it's a robust plan.
You know, when I started at Colombo Herd, we only had a few clients that would use like your service that would do business plans. And there were some reasons for that. And as I was talking to the attorneys who worked here, we talked about the importance of having a plan. And, you know, some of the pushback that I got was, well, this is prospective. And I'm like, this is still an employment based petition, right? It needs to have some reality to it. Like, why you're killing me, you know, like, and, you know, give it some reality. And, um, you know, many of our clients are not in the US. They don't have the professional network to bring their endeavor to the US, even in a preliminary way, right? They're not traveling here for work and doing some side things, you know, setting up a business or incorporating or doing any of those things. And so it is difficult, if not impossible, for them to carry forth some of these things that officers are looking for. And so the bar is being raised. It's not, they're harder to get. Um,
Mhm.
and it has to be a little bit more real. And I don't know that um, I disagree with that completely. It wasn't how we adjudicated things when I was an officer, but I don't know that I disagree with that evolution. And you're right, you know, comparing it to an E2 or even sometimes an EB1, like the RFE that I was venting to you about that day was, you know, it just felt like it was being evaluated on an EB1 level instead of an
Mhm.
EB2 level. So
Exactly.
they're getting harder to get. And I think if we all get smarter and collectively move in directions that provide the officers more information and more substance to make their decision on, I think we'll continue to have success in this petition type. But you know, I think we have to like share our best practices, and I think we have to be transparent with our clients about the risk level, and I think we have to adjust our own expectations to that, right? I mean,
Exactly.
I have to do that all the time, right? Like I think I know
That's a
what
big
I'm
one.
doing. I mean,
Exactly. That's a
silly
big
me,
one.
right?
Yeah. No, and you've seen the data, right? It used to be 90% approval, or at least very close to that, and then it dropped
Yep.
to 80%. So the numbers are there. There's higher scrutiny, the bar is higher. And on the business plans, when we started doing EB2 NIWs, people didn't add a business plan. That started coming after RFEs were saying, hey, you should include one. So then we started seeing more people do it at the initial filing. And then they started getting approvals, and then they said, well, maybe I don't need it at the initial filing, but I might need it at the RFE stage. So that happened as well. And then now, after the updated policy, we're seeing more people go back to the original statement, which is let me file it very robust, let me include everything I can to be in line with that higher scrutiny. And now that I mentioned the policy update, can you tell us a little bit, Mandy, about what that policy entails? What things should we be looking at there from that update?
Yeah, I think that update does a little bit more to incorporate, you know, to kind of articulate how they're thinking about the the role of the critical emerging technologies list in the NSC document. And so I think the clarity there, the thing that they hadn't said before was how they want the tech innovation to connect to a national priority, which is articulated in the NSC. And it just gives you that big list, right? That list of things that they're looking for. And I was going over the policy manual yesterday, and I was like, wow, they really expanded all the things that they're looking for. And so I would, it's my plan and my practice to really, go into that list and think about hitting as many of those components as I possibly can in any given petition, and making sure that if I'm doing a technology endeavor, that I'm really connecting that to something that's critical, and connecting that to those national goals of security, economic prosperity, and the spread of democracy. For as long as that NSC document exists, I'll be looking at those, right? Because if we think about all of the technology that goes to democratizing information, democratizing access to finance, democratizing skill sets, things like that, I'm going to be trying to tie that work to that spread of democracy, because, and economic prosperity, right? Because I want to make sure that the officer has something in the file that says this work is connected to a priority technology and a priority goal. So that was kind of my take on that memo. What's your take, Marianello? I mean, what did you think about that thing?
I mean, we were happy to see that the business plan was mentioned. I can tell you that for sure. But yeah, in general, and also like our point of view from our team, we took it and made sure that everything is included in all our process of building the business plan. But aside from that, it was a little bit more of strengthening what we already know from experience, but it was clearer. And then also the same, like focus on what kinds of documents to receive specifically on those emerging technologies, which was important as well. Thank you, Mandy, for that. We have a lot of questions, so let me let me start on that. Some of them, I mean, I've already done, and most of them are answered, but I'll try to go to the ones that we haven't. Okay.
Okay.
So, okay, we did the one about the mailing. Okay, this one is also tied to the new administration. So, and perhaps you consider this one is already answered, Mandy, but I'll include them both. How do you expect the executive orders will be applied? And also, if there are irrational vendettas against renewable energy endeavors.
Yeah, so Trump doesn't like the renewables because I think he thinks that it rubs against the oil industry and their influence and contributions to his campaign. I don't think that's true, but I think that is an accurate representation of how he views renewable energy. I still plan to do renewable energy endeavors, and I just plan to approach it without those executive orders. It's still critical. The technology is still critical. The environment's still critical. There's still support on different state levels, and most places have taken kind of a dual approach, right? There aren't very many governments in the US that have taken an approach to energy initiatives that does not include combined efforts, right? Because there isn't enough infrastructure currently with renewables to have that really replace fossil fuels, and at the same time it's cheap. It's the whole market is evolving, so it's getting more accessible to use renewable sources, but that infrastructure still has to be built, and that's still going to take time. So yeah, I mean, is he taking things away on that? Sure. But can you still do it? I think so. I mean, I plan to. Um, again, I mean, I think that we have, find some regional work, find some states that have prioritized this, find some national um, NGOs that are prioritizing this work, connect it to other things, connect it to public health, connect it to the spread of democracy, right?
And
Um,
economic prosperity.
economic prosperity and energy security. Energy security is hugely important to the US, especially as related. So Trump wants all these pipelines going through, from Canada through the US because he has people who have contributed to his campaign to ensure that that happened. I don't know that he is really thinking beyond that. But if you think about the last, 40 years of the US trying to make sure that we could do more on our own and we could start to separate ourselves from our international relationships with unstable regimes around the world, that still exists. So, spread of democracy
Exactly.
through energy independence.
Okay. That's clear. That's clear. That's super clear now. I mean, we've touched a little bit on this, but we can maybe go back. Why are USCIS officers inconsistent in their approach to well positioned, substantial merit, etc.?
Training, and it's a discretionary benefit. Everybody, I mean, there's just, and background, right? So it's not just, your NIW training, but it's like whatever you're bringing. So for a little while, we were seeing questions about, were you going to be a public charge because people weren't showing any revenue from their endeavors? Anytime you see a question about public charge, you can bet that somewhere in that officer's past, they did 485 work, because a public charge is a barrier to a green card. So there's all these different spots that officers are getting pulled from. So it's background, it's training, it's discretion, and I think maybe a lack of oversight. So when I was an officer, one thing you should all know is that from time to time when I was an officer, they would look at trends, right? RFE trends, denial trends, and all of it, because of that software, they can track how many NIW, RFEs, and on what matters are being sent out. So they have all that data. And it's not hard for them to look at that data and say, we have too many RFEs going out, or we have too many denials going out, or something like that. And then they come back and they look at it and they design some training around what they think the issues are. So, for example, not too long after I was trained on NIWs, maybe the first quarter, I want to say, they called us all back in and did a new burden of proof training because they didn't feel like the burden of proof was being consistently applied. So I don't know if that's still happening. That was a very strict practice at Nebraska, but with the portfolio system and just all the other things that have been going on, I don't know that that's happened yet. Or alternatively, management knows exactly what's going on and they support it. That could be happening too.
Exactly. Yes. There's a question about, is critical and emerging technologies list dead? That's one of the
I
questions.
mean, I don't think so. It was just reiterated in that memo. But I think the memo, again, my interpretation of that memo was basically they want the CET and the NSC to be connected, right? And so they want those critical and emerging technologies to be connected to um, economic security, spread of democracy, and national security. So I think if you use the CET, you need to connect it to one of those priorities. I think in the most conservative way, in the most conservative reading of that memo, that's what I think you should do.
Okay.
But I don't think it's dead.
How long should an EB2 NIW file be? And is it better for an officer to receive a very detailed case or not necessarily?
So I don't think anyone should have a page count floor or ceiling in mind. I've seen well-developed petitions at like the 500 page mark, and I've also seen them at the, closer to 1,000, 1,200. So prepare your petition well. Don't fill it with unnecessary things. And don't overdo your cover letter, right?
Yes.
So
This is a big one.
if your cover letter is more than 10% of your petition, you might think about rewriting.
Okay. Okay, perfect. This is important. Okay, this we answered it. This we answered it. There are many. Do we get the same officer reviewing original petition and RFE response? And if not, what's up?
Usually, yes.
Okay,
Usually,
and that's
yes.
a big one for what you were talking about before,
Mhm.
about either replying to the RFE or refiling. Okay.
Correct.
What is now okay, we went through this. Is USCIS looking for candidates with master's degree mainly, or the experience matters?
So I think that both matter. I mean, certainly for easy preference class qualification, a master's is great. I don't know that I think that officers want to see the experience too, because they want to see that body of work. They don't want to just see academic credentials. They want to see that you've done things. So I think the experience is important, although I think sometimes we don't do a great job of displaying it. We kind of tend to do employment letters or letters of recommendation that talk about some of the highlights and just the overall duration of the person's career without really getting into some of the things that they've done. So I think the question should be, is your client's career presented well in the petition, not whether the officer is hung up on education or work experience. Keep in mind, the officers usually have a combination of both too, right? Or some, and there's a range there too. There are officers at the service center who have no formal education. They went to high school, they got a job in the mailroom, and they've been there ever since. There are people, conversely, who have, PhDs. There are a few JDs there. It's rare to find pure education snobs within the adjudication corps, my experience.
Okay, so it becomes subjective.
Subjective and keyed to the evidence about their accomplishments and their acumen, right? Because it's not just about the credential. I mean, the credential is important too, but what have you done with that? And is it connected to the endeavor?
Correct. Back to the impact. I have a question. Explain the criteria to establish a zone as underserved community.
So I saw that question before, and I'm not sure I totally understand that question. I think that there's maybe two components to that. So maybe you're referring to the IRS economic redevelopment zones. I think for those, if you're looking at economic redevelopment, there should be data from the government, either state, local, or federal, on that being a targeted zone for redevelopment. If you're talking about underserved communities in terms of like NIWPs, there are maps for that as well. And those will delineate practice area and specialty and geographic area as well. So I wasn't completely 100% sure how to respond to that. But I think, when you're thinking about the economic impact, one of the things that I train on internally at my firm when we talk about economic impact, if we're designing an endeavor to target a zone for economic redevelopment, like an IRS poverty zone, there's a couple of things that you want to do. One, you want to show that you can hire from that local community, that your endeavor will include staff from the local community. And then you want to show those impact factors, right? So for every job that I create, how many other jobs in the community are created? So job multiplier information, revenue information, and whether my endeavor is going to employ local people, right? Because it doesn't do any good to show that I'm doing economic redevelopment if I'm importing everyone who is going to work in my company, okay? But if I can pull from the local community, for example, anyone who's doing anything with in the auto industry in the Detroit area. The Detroit area and Ann Arbor, they have a lot of local employees. They have a big base that are well educated and have experience in the auto industry that have been doing other things since the auto crash of 2008 and 9. So when you look at creating an endeavor in like the Detroit area that's related to auto, you can show that you can hire from that local community. If you're going to be doing something, related to auto manufacturing in a community where there isn't that population base of, that expertise in the local population base, I think you have a tougher hill to climb. So you have to be thinking about those. And a lot of our clients already are, right? They're starting a fintech automotive company. They're providing EV parts in Ann Arbor, things like that. And so when you look at that local population, you have to think about, can I hire from here? And does this population have what I need? I think that's the best thing, unless it's a question about NIWPs. And then there's just maps with NIWPs, and you just have to follow those maps.
Exactly. Mandy, I have like 5 to 7 more questions, but I'm going to stop here to give people the CLE credit, and then we'll continue, and then we'll finalize. So the CLE credit number is 2500811, N as in Nancy. That's 2500811, N as in Nancy. Thank you, everybody who has stayed at this point. We still have like 300 people connected. And everybody gets the recording at the end. So if you have to leave, you can check the final ones that you missed. Let's go on. Do the officers have an RFE or denial quota?
No.
Okay.
No one cares.
Are officers instructed that some fields offer national importance while others aren't? Is there anything that's more national interest waiver worthy right now?
Not that I'm aware of. The only thing that, so there's a couple of things, right? Obviously, teaching endeavors are difficult because of the language in DANISR. And then for anything that, medical providers need to show their ability to be fully credentialed in their local area based on their medical credentialing, ECFMJ or the other versions of that for PTs and dentists and etc. So for providers, they have to be able to show that they can practice. And teachers obviously have a tough hill to climb as well. They have to show the broader impact beyond the individual classroom. But other than that, no, not that I'm aware of.
Great. What types of evidence does USCIS expect in support of letter of recommendations given confidentiality constraints?
So I think this question has to do with, a business testifying about a person's contributions and then not being willing to provide the business records of that. So I do think that this is one of the spaces where there's a disconnect between the adjudicators and the private practice, and they're just the realities of private corporations. I don't think that they understand that that's the barrier that it really is. And that's something, I mean, I still have connections there. And so I try to hammer that one and a couple of others home when I have the chance, right? That no one's coughing up their business records. I try to, where possible, especially in the incidents of having an RFE issued, I try to get them to provide something, right? Send me a copy of the email telling this employee to do this work, right? Or, even if you don't want to show me the work that was actually done because you think that's proprietary, show me how you assigned that work to the client. Show me how they were reviewed for it. Show me how that work was recognized. All of those things, the businesses need to get their heads right about how they're supporting their employees around that issue, because I don't care. No one cares about your proprietary information, if I could talk. No one cares. And I understand that they have maybe some concerns over the FOIA process or that information getting out into the market or something like that, but there are certainly bigger vulnerabilities to their information being shared than through, the expiration of a person's individual A file. So they need to get their heads right about being able to connect the dots in terms of what the employee is doing, even if they don't want to share the final work product of the innovation or the development. They can at least show that that work was assigned to that person and that they completed it well and that it had a critical outcome. They can fuck off.
Thank you,
Sorry.
Mandy. No, you've been so kind and very generous with all the information. We appreciate it. How do you justify the job waiver when you are filing for someone who already has a job?
So it's not a job waiver, it's a labor certificate waiver. And you justify that by saying this job doesn't fit into the kinds of jobs that labor certificates are designed to serve, right? So labor certificate roles are standard roles, right? So you have a standard occupational code, you have a standard job description, a standard rate of pay, set skill requirements and education requirements, and all of that is like very uniform throughout the field and some uniformity in the geographic location. So when you have national interest waivers that vary from that, it is appropriate to request a waiver based on the unique skill set of the individual, the unique job of the individual. So these jobs, in theory, provide some and allow for some different skills than a standard occupation. Okay, so if I'm a tech entrepreneur, I could easily qualify for an I-140 second preference class labor certificate case as a software engineer at Amazon. All right, that's going to be my standard occupational code, and that's a standard job with some regular education and work experience requirements and technical requirements, right? Specific code languages. But if I'm an entrepreneur, right, maybe I need all of that plus some other things, right? Business development, managing people, creating a business that other people can invest in, marketing my product, making connections within my field. If I'm an employee, I think about this in our own lives, right? For those of you who are practitioners in firms and the work just comes to you on an assembly line, and you never have to think about where that work is coming from because the partners do that or whatever. That's your standard job. When you leave that job and you go out and start your own firm, you have another skill set that you have to develop, right? And it's not the same job. Are there still overlap? Of course there is, but it's a different job. Managing a law firm is a different job than being a lawyer, even though you still could have a caseload, even though that can still be the majority of your day, you're going to have other things that you're thinking about. And so when we think about entrepreneurial endeavors, or we think about just unique or field crossing kinds of endeavors, that's where you get your national interest waiver pitch, right? This isn't a standard job, and this isn't a standard employee. They have unique skill sets, they have unique abilities, they have unique experiences that make them qualified to advance this specific work. Thank you very much, officer. Please approve it.
I'm a friend. I'm Mandy's friend.
Right.
How are filings assigned? How are filings assigned to adjudicators? Do they eventually specialize in certain fields, or should petitions be simplified so the adjudicator understands the material?
Can you repeat that? I'm sorry. Okay, so how was it assigned, and then there's something else?
Yeah, like if there's any specialization in certain fields from adjudicators, or if it's needed that some complex fields might need to be simplified so the adjudicator can understand the material.
Yeah. Okay, so work is assigned based on what you're approved to work. And it used to be assigned through a system where you would request the physical files, and you had to request the physical files based on particular types. Now that's all done electronically. Officers are not sub-assigned based on professional field or subfield. That's way too much nuance. First of all, there's no way to track it, and there's no easy way to ascertain that in the kind of high-level review that comes with assigning the type of work, right? Like everyone knows instantly if this is an NIW petition because we say so on the front of the form. No one knows what kind of work they're going to be doing until they get into the I-140. And so that's already too far for anyone who's compiling or putting that file into the computer.
Okay, understood.
Good question though, and I wish we would do that in the private world. Like that's something I've advocated for at my work, because I think that if you really track your own approval data and the approval data that's going on in your firm, you'll find attorneys and teams, support teams as well, that have strength and get higher approvals with certain professional fields. And that's because they understand the field, or they connect with the professionals, or whatever that is. I don't know what my data is right now. I refuse to look with everything that's going on, but I just know in my heart, I have such a soft spot for engineers, like they do their homework so well. But I love everyone, but I know I have that inkling. And so I encourage everyone to track their cases based on professional field and think about client development, think about your own skill development and what is a good fit for you, and specialize in it if you're up for it.
Thank you, Mandy. A few of the last ones, I promise. We are seeing lately a lot of denials based in part on the fact that USCIS is not taking into consideration new evidence or changes to the business plan. But considering RFEs are asking advance in the endeavor, how can we present these advances, even the new funding alternatives for the endeavor?
I think you have to do that at the front end, because what they're going to say is, oh, you just did this in response to the RFE. If you have evidence of funding, that should go into the initial filing, and you should talk to your clients about obtaining that prior to the initial filing, even if it takes longer to get it out the door. I think that it's, anything that's done in response to the RFE that didn't exist before the RFE was issued, right? Like we found it and we're including it now versus we created it as a response to the RFE, they're not going to take seriously. You wouldn't either.
Exactly. Okay. Given the fact that an officer does not spend time reviewing the file, or not a lot, should we rely on summaries, tables, and pictorial explanations in addition to the detailed explanation of the impact of NIW?
I don't hate that idea.
Okay.
I don't hate it. So don't get me wrong, they're going to look at your stuff, right? I think if you have things that explain or make it easier to understand the impact, I think I would include that, because national importance and the prospective impact are two super important components, and it can be tough to describe those. So if you have infographics, yes, do it. Shouldn't be the only thing, right? You want to unpack the box.
Yes. Okay. I have a ton of more questions, but I need to tell everybody here and also people who are going to watch the recording that we need to do a Mandy Nease 2.0 webinar. And we are having one actually. We're going to do a summit. We're going to have Mandy have an open Q&A, and that's going to happen in March. We'll keep you updated on that because I think there's not going to be enough time for us to go into all the questions. The good thing is that there are questions, so that's positive. And we'll have the opportunity to ask Mandy those in the Q&A in March, but we'll update you on that as well. Thank you everybody for being here. Mandy, do you want maybe to give a closing remark?
I just want to say to everyone, thanks for being here. Thanks for sharing your day with me. Thanks for sharing all your questions with me. I do understand the frustration with USCIS. I experience it too. I don't have any, magic to make that better for myself or my clients, and so I totally get it. I would just say, just remember these are people too, and their jobs are important to them. And when you're thinking about the impacts of Trump and his work toward dismantling humanitarian immigration, also think about his work at dismantling the federal workforce and how disastrous that would be. And remember your advocacy and your role in our democracy when it comes to those things. And otherwise, I just thank you all so much. It's an honor to be a colleague.
Thank you so much, Mandy.
Thank you,
So,
Mariana.
yeah, a message to everybody. You need to breathe, do a lot of mindfulness to also try to channel the venting that comes, because there's a lot of life-changing decisions that are going through a lot of people's hands as well. Be straightforward with the cover letter, not too long, table of contents on point, explaining each exhibit. Add the business plan wherever you can, please. Manage your client expectations for sure. And yeah, and do everything that you can on the things that you can control to try to minimize the situations that may arise with the adjudication at the USCIS point. Thank you so much, Mandy. We're so lucky to have had this time with you. I know we went way longer than expected. So we really appreciate it. And then we'll tell everybody when the date and the time is for the Mandy Nease 2.0 Q&A. Thank you so much, Mandy. Thank you, everybody.
Thank you. Bye-bye.
Bye.